bit of an unusual way as a Fulbright scholar. And she began this, apparently an obligation of the Fulbright program is that you have to undertake a non-trivial research project, more of the nature of a short monograph than a simple scholarly article. And she chose to work on tenure review in New Zealand's high country, the eastern slope of the Southern Alps. And I had the pleasure of making Anne's acquaintance a year ago, and we eventually became co-authors. Okay, Anne, tell us about it.
Thanks very much, and I'm very pleased to bring you in on a big puzzle that's been puzzling me for about close to 2 years now. And as we go through, as I sort of lay out pieces of the puzzle, I'm sure you'll hear veiled reference to many theories with which you're very familiar. I may not mention the theories by name, but I'll be giving you clues, and I think you'll probably recognize them. So we're talking about a land reform process, which is a massive redistribution of wealth and resources on the South Island. It concerns about 20% of the South Island, or 2.4 million hectares. A basic tenet of natural resource politics, law, and economics is that the use rights, the authority or the ability to use resources in land, can be separate from title. So the owner of title can allocate use rights to another party. In this case, the Crown owns all 2.4 million hectares, but has allocated use rights to lessees. So the Crown leases out grazing rights and occupation rights to pastoral leaseholders. And now the Crown is in the process of taking back some of the land to put into parks and reserves and privatizing the rest. So it's a big split up of about 20% of the South Island. So here we can see a lease that has already gone through reform. So before reform, all of this land, all the way up to the top, and perhaps beyond, I'm not sure, was all leasehold. So owned by the Crown with pastoral grazing rights and occupation rights, leased on a perpetually renewable basis for very low rent to leaseholders, farmers. Now, this lease has been reformed. So the land capable of commercial use, capable of economic production, is privatized, and the land with conservation and recreation values gets transferred into the Department of Conservation for public conservation land. So land with resource production potential gets privatized, and land with sort of conservation and recreation potential gets nationalized. So far, about 58% of the land has been privatized, and about 42% of the land has gone into public conservation land. And in this process, after they sort of figure out who's going to get use rights to what land, there's an equalization payment. So if there's a perceived inequity, they sort of buy each other out. So the Crown buys out the lessee's grazing rights, and the lessee buys out the Crown's freehold title and development rights. And in this process, the Crown has paid the lessees about $31 million so far, and the lessees have paid the Crown about $16 million. So in aggregate, the lessees have received freehold title to 58% of the land and $15 million. And the Crown has received grazing rights to about 42% of the land. So therein lies the puzzle that I think of. Yep.
So is one option here that the Crown just chooses to buy some of the grazing rights land and set it aside for parks and conservation, and then not privatize utilize the remaining, that's also an option here.
Well, legally, yes, it is an option. I mean, there's two statutes that govern this. The first is the Land Act of 1948, and the Land Act specifies that the property rights assigned here are compensable. So if the Crown wishes to extinguish a lease to establish a reserve or a park, it can do that in the name of the public interest, but it'll have to compensate. So, yes, if the Crown if the Crown's goal were to establish parks, then it could do exactly what you said. But in '98, they passed a law that sort of legally sanctioned this reform, and one of the goals of the reform is to diversify land use of the lower country. So generally the lower land below 1,000 meters gets privatized, and the Crown was interested in diversifying land use. And in order to diversify land use, they decided that the most efficient way to do that was by allocating a whole new set of property rights. Yeah?
It's also the case, isn't it, that if the government were to acquire the grazing rights to the land, not because they paid a sum that farmers willingly gave up, but because they exercised the eminent domain rights,
yeah,
that if they were to then choose not to put into conservation but to sell it to farmers, they would have to give the original owner first of the grazing rights first refusal. Isn't that right?
That I don't know. You could be right. I don't know. It's not in the Land Act, but
I thought there were precedents with.
It could be. You could be correct. It's not written in the Land Act.
That had previously been taken illegally under misuse of the Treaty of Waitangi, and then the question is who's the original owner of the first right?
That could be. I'm not sure. I haven't read of any such precedent with pastoral leases.
One question: how long are the leases for?
Yeah, we're going to get to that. They're for 33 years, and they're perpetually renewable. So, we look at tenure review, which is the name of this policy, as a bilateral exchange of property rights. Whether or not that's how the government looks at it is a different question. But what's going on here is the Crown is resuming grazing and occupation rights in order to establish parks on the sort of land above 1,000 meters in general. And the Crown is giving freehold title and development rights on the land that's most capable of economic use. So the Crown is sort of freeing up the development rights that have been constrained and withheld while the land was under lease. Because while the land is under a pastoral lease, they're only allowed to graze sheep. Any other uses, they need permission from the Crown. They're not allowed to subdivide, they're not allowed to build. Industrial uses, condominiums, golf courses, viticulture is prohibited without Crown consent. And the Crown does give consent to do lots of things like fencing and fertilizing and things like that, but subdivision would be highly unlikely. Yeah?
Yes, can you clearly distinguish for me the distinction between land that's capable of economic use and land that isn't? Because if you're suggesting that land that has conservation or recreation value, are you suggesting that it has no alternative value? And consequently, what has been transferred so far is something that has no social opportunity cost?
Well, I think our colleagues from DOC might be better able to answer how they determine. I mean, capable of economic use is a somewhat vague term.
Well, I'll let DOC have their say in due course, maybe, but I'd like to hear what you've got to say. This is your paper, not theirs.
Just give a specific example. I mean, a ski slope, for instance.
A ski field would be, there are some ski fields in these pastoral leases. So the Crown has granted permission to do ski fields. In general, the ski fields get privatized. So any land that is altered in some way, like by fertilizer or fences or ski fields, correct me if I'm wrong, tends to get privatized. If that's what I'm not sure if I'm answering your
I
question.
think you've already answered the question with your numbers. The government didn't pay zero to acquire the land that has no economic use.
No, the government pays a positive price. Yes.
Yes, and that presumably was regarded as fair compensation. That suggested that economic use.
Yeah, yeah. I'm not saying that the land that goes to dock has zero economic use. No, that's not what I'm suggesting. It does have a value, yes. Yeah, Phil?
I gather from you in reading things like this, that the main geographic differentiation between the 58% category and the 42% category is, frankly, depth of soil and tilt of slope. All right? If it's fairly flat, if it's a paddock, if it's more or less a paddock that supports meadow grass of some kind, it is privatized. It is deemed to have substantial pastoral value. If it's a scree slope, 30 degrees, it's deemed to have only recreational value. Now, the farmers are claiming that the very high country pasturage on steep slopes has value because it captures the more winter moisture in the form of snow, and is a valuable alternative. It's a valuable alternative for summer grazing. It's an argument I only learned in the last 10 days. But
there are economic uses possible on the high country. Some of it is glaciers and scree. Some of it is valuable summer grazing to the farmers. Yeah?
You've got quotations around capable of economic use.
That's in the statute.
Yes, okay.
Yeah.
That's rhetoric rather than
it's a statute. I mean, it's from the law.
Yeah.
Okay.
It's in there as rhetoric, not in there as definition.
Well, there aren't really. There are 4 goals of this land reform, and they're very ill-defined. The first one is to promote ecologically sustainable use of the land, except they've never defined ecologically sustainable. And then the second one is to make possible land that's capable of economic use gets passed in a freehold title. And then the third one is land with significant inherent values gets passed or gets conserved, preferably by public ownership. But it could be by covenant. So it's an enabling. Well, the way that the government officials, the LINS officials describe it, they describe it as an enabling statute, not a strict, you must do this, this, and this. And so it leaves a lot of room for interpretation by the administrators. So as we'll go through, we'll see this act is largely administered by government contractors. And so the lack of definition in the goals of the act creates a fairly significant principal-agent problem between the Crown as principal and the agent as contractors. Yeah.
So just to get a little more institutional knowledge, so these leases, you said for 33 years or 33 and a half years?
33, yeah.
Okay, and then the Crown is obligated to renew that lease at the end of that time, or could they just say, oh, lease is up, we're going to do what we want, no compensation?
No, they would have to compensate.
So there is an expectation.
The Crown can rescind a lease at any time with compensation.
No, but when the lease expires, what's the obligation on the Crown?
There's still compensation. If the Crown were to say to not, unless there were some breach of terms, and there is precedent for rescinding a lease due to breach of terms.
Mm-hmm.
Yeah.
how much precedent?
For significant precedent in the last 5 or 10 years. Yeah. There's only 304 of these things, so there aren't going to be dozens and dozens and dozens of precedents. This is a small country.
What does the 33 years mean?
What's that?
What does the 33 years mean then? If it turns out that effectively when you own this lease, or when you're leasing the land, it's for perpetuity, then what does it mean to have a 33-year lease?
Well, the rents are reviewed every 11 years.
Farm lobby groups very aggressively use the adjective perpetual and in perpetuity.
in perpetuity, which is incorrect, but,
They believe that these are perpetual leases.
okay. You are correct. The property rights conveyed by pastoral leases are very strong. They're not in perpetuity because common law prohibits in perpetuity, but they are perpetually renewable. These property rights are exclusive, they're compensable, they're legally enforceable, and they're transferable. So in contrast to the U.S. grazing permits, you can sell these leases. You can't sell a BLM grazing permit in the Western U.S. Also in contrast to the U.S. grazing leases, they're exclusive. So in the U.S., you're not allowed to restrict access. You can't prohibit a mountain biker from mountain biking through your grazing land. But here you can. So the property rights that are allocated are very strong, but they're very narrow. They're for pastoral purposes only. So there's been quite a vigorous debate over the past 9 months since I gave my Fulbright report to Fulbright and sort of naively thought that only Fulbright would ever read it, if that. In that the farmers and their advocates have been advocating, but we have very strong property rights. And I agree. It's just we tend to bow down in front of property in blind and silent reverence without bothering to look at, yes, they're strong, but hang on, what exactly are they? They're very strong property rights to grazing. And grazing has a very different value from development. So the property rights that the farmer holds, he holds very strongly. And the property rights that the Crown holds strongly as well. But there's two separate bundles of property rights, and they will have two values. So our question in this research that I'm presenting today is, do the values of these two separate bundles of property rights, grazing and occupation, and development and freehold title, do the relative values drive the prices that are assigned and paid in tenure review?
The key thing here is the difference between a freehold and a lease. The key issue is the restrictions on use. 33 is completely irrelevant. Yeah,
the 33, it's just sort of a descriptor. And the perpetually renewable, it's an adjective. And they all describe grazing and occupation. So the perpetually renewable sounds really strong: exclusive, compensable, enforceable, 33-year leases in perpetuity. They're all adjectives, and they all describe grazing and occupation.
But the consequence of that simply restricts the property rights to the Crown to simply the present value of its real income.
That's one theory that we're testing, and that's one theory that's been presented. The farmers have presented that theory, that the development rights that are passing don't have any value to the Crown, and therefore the value of the Crown's interest is only the net present value of rent. And that's one theory that we're testing. So we're testing, okay, is this the way that prices are assigned?
My development rights precisely what you refer to.
The right to develop. So the right to subdivide, the right to, or the ability to, in New Zealand it's more accurately described as the ability to apply for resource consent to develop the land beyond extensive pastoralism. While the land is under lease, the lessee is restricted to extensive pastoralism. So development would include subdivision, viticulture, fertilizer, planting. You have to apply for consent for that. Planting grass seeds, putting in fences. So he's got strong rights, but they're narrow. So development is anything beyond extensive pastoralism, anything beyond extensive grazing. And up to and including subdivision for residential lifestyle homes.
But historically, there must have been considerable development of this land paid for by farmers
Well, it was actually heavily subsidized by the Crown until 1990. So, yes, there has been fertilizer and stuff applied. And you're right. I think what you're getting at is that the farmers own all improvements. So when the Crown resumes 42% of the land, they have to compensate for the grazing rights, but they also have to compensate for any improvements, any fences, any fertilizer, any rabbit control, any the Crown wouldn't resume a house, but if there were a house, because they're allowed to live on this land and they build houses, but that land tends to get privatized. That land doesn't tend to go into the conservation estate. So yes, the farmers do own improvements, yes. Okay, so
just one thing on the 33. One of the questions was why the 33 leased, and it's totally ineffective for everything. Seamus, that's what you're suggesting, right? That it was useless.
It's minimum.
Because I don't think it is.
When rent is reviewed every 11 years.
No, but I think well, possibly, but I also think that the limitation is, for example, people file, they don't go in, they don't develop, they don't do anything, or they cut out early, and it's like a registration requirement, and you've got to come back in to the office, sign up for your next rights, and if you don't, then it's canceled.
It's a generational thing.
Yeah, perhaps something like that. I mean, I think it was just a thought. It's not an important thought, but.
So this research is all predicated on the idea of real property being a bundle of rights. And that bundle can be split among different parties. In this case, it's split between the Crown and the leaseholder. So a full bundle of rights, generally economists and lawyers and political scientists refer to control and management of the resource, excludability, transferability, and enforceability as sort of a complete bundle of rights. And more, it's in natural resource politics at least, it's the idea of fully public land or fully private land is outdated. There will always be public rights in private land and private rights in public land. So the idea of a single bundle of rights that is not sort of tainted by any other interests is outdated. And so you could argue, and some have argued, that the idea of trying to create two entirely distinct bundles of rights as a very effective way of managing land might be outdated, because there will still be public interests and public rights in this new freehold land, and there will always be private interests and private rights in the public conservation land that's being established. Although it has been an argument that's been raised a bit by the farmers, but not very effectively in the legal sense. So, while the land is under lease, the rights and duties, property rights and duties, are split among the farmer and the Crown. The farmer has rights to occupation, pasturage, to hold all improvements, regardless of whether those improvements were subsidized by the Crown, as most of them were until about late 80s, I think. And the farmer can also transfer, sell, bequeath the lease. Just an aside, the reason I sort of got interested in this topic in the first place is because I heard that Shania Twain had bought a leasehold, and I thought, hang on, you can't do that, because in the U.S. you can't buy interest in public land. You can acquire them from the government, but they always revert to the government before they change hands. So no one could ever sell an interest in public land to Shania Twain in the U.S. And that's sort of what. And then I heard about the whole land reform. And so the leaseholders also have duties. They're, as Seamus said, they're a bit more rhetorical than very specific, but they have to practice good husbandry and farm the land diligently and avoid committing waste, and they have to keep, this is 1948, they have to keep the land free of pests, most notably rabbits. Rabbits are a big problem on much of this landscape, and rabbits will play an important role in the story that we're talking about. The Crown also has rights, and the most crucial right that we'll be talking about today is the right to adjudicate all land uses other than extensive pastoralism. The Crown doesn't have the right to go in, march in, and build condominiums, because while the leaseholder has exclusive occupation, the Crown can't do that. But the Crown withholds the right to build condominiums from use. So the Crown holds the right to adjudicate or decide whether that condominium will be built. That's the nub of the philosophical, economic, and legal question that's been raging for the past 9 months, and that's the nub of the hypotheses that we're going to be testing. What does this right to adjudicate future land uses other than extensive pastoralism, how much is that adjudication right worth, and how is that valued in the process? Yeah?
The ability to, let's say, proscribe the way in which the land can be used is rather like a regulatory taking.
It's not a taking because it was never there in the first place. Because you can't take something that you've given away in the first place. Because, okay, this is a dispensation of land not land, resources. In 1948, starting in about 1856, I should say. Starting in 1856, the Crown decided that it would, in an effort to sort of build a colony and build a nation, the Crown decided that it's the same as in the U.S. and Australia and other sort of colonial societies. The Crown decided to use property rights and use natural resources as a way to build a nation. And so they decided to allocate certain rights in natural resources as a way to build an economy on the South Island and hence build a nation. They decided not to alienate the land itself, but only because it was too fragile. That's the rhetoric. But only to allocate the resources. And so the Crown isn't taking development rights because the Crown never gave those away in the first place. It's a lease.
What I mean is that initially, the fact that it constrained people from using land which they could use for alternative purposes only for one purpose is rather like a regulatory taking.
No, it's not. No, it's not. Because to take something, you have to have given it away. And the Crown held the land all along. Now, you could argue about the regulatory taking the land from Maori. Because in 1856, the land, it's quite a coincidence, but in 1856, when these leases started, that was the massive expropriation of land from the Maori in the eastern slope of the South Island. But no, it's not a regulatory taking, not at all. Nope.
Well, I take the point, but the issue is that if you consider it to be a constraint placed on the use of land, which has been used, it's a use of land constraint, and the land is being allocated on the basis of perpetually renewable leases, which gives, as you said, strong property rights to lessees, and which may not be too distant from those which would occur on freeholding. Now that's arguable, I agree. But suppose you buy that argument
that's one of the arguments that we're testing,
Suppose that you buy that for a moment. Then in constraining those rights for a start, where other rights and other things which were leased or perhaps sold were not constrained, that is an aspect which is similar to me for a regulatory taking.
It's a regulation, it's not a taking.
We view it as an ex post.
Okay, fine. My issue is that of compensation. Generally, regulatory takings, certainly in this country, are not compensable. Whereas
they are under the Land Act.
Are compensable. Sorry, regulatory takings are.
Okay.
takings are. There's a fundamental difference.
Well, but actually, there's no takings, there's no constitution, there's no takings clause.
Oh, no, it's Public Works Act. No.
Okay. Well,
No,
in any extinguishment of a lease is compensable. So the takings question isn't really all that applicable here, because you don't have to go to any sort of constitutional body of law to decide that it's compensable, because it's right there in the Land Act.
A takings can occur in this context only if the Crown unilaterally varies the terms of the lease at renewal time. Then a takings, if it's adverse to the leaseholder's interest, then you have a taking. But then such a variation of the terms of the lease
Taking
does not
is a
come up
term
in
of art.
conversation.
It's not a, that's a very, I'm American, but that's a very American term.
Yeah.
It's the Fourth Amendment. There is no such thing here.
Richard Epstein has lectured twice in this university in the last 10 years.
Okay. Anyway. Let's
No,
talk
you
about.
understand, but no, if your farmer, if at the outset the farmer agrees to a lease, the terms of the initial lease and renewed in perpetuity cannot be a taking. They can be harsh, they can be unconscionable, but they're not a takings because he agreed to it, or his ancestors agreed to it from the outset. I agree with you, there's no takings.
And takings isn't
It would
really
be-
an applicable.
No, it's an
American.
And ours is it's an economics term. It's a hard economics term, independently of the constitutional issue.
Well, let's talk about how these deals are negotiated about that, because that's an important question. The negotiations are administered by an agency called Land Information New Zealand, or LINZ. And LINZ is a strong adherent to the politics administration dichotomy, in which politics and administration can and should be entirely separate. So administrators can and should be neutral. And these deals are negotiated by contractors, private contractors who work for real estate development companies such as DTZ, Opus, and Global Value. And since 1998, they've been instructed to act neutrally, to be a neutral broker, and to not advocate on behalf of the Crown. This was news to me. The contractors aren't actually allowed to talk to me, but one of them was kind enough to talk to me off the record the other day. And apparently when LINZ took over in 1998, they specifically instructed the contractors not to advocate. According to, I can't validate this in any way because they're not allowed to talk to me, but according to one, prior to 1998, contractors advocated. After 1998, they didn't. And there's been up until September of this year, there's been little to no ministerial oversight of these deals. So the contractor makes a recommendation to the Commissioner of Crown Lands. The Commissioner generally accepts it. They said recently in the North and South magazine that their job is not to relitigate what the contractor has already figured out. And until September, the Minister didn't have signing authority. So once it was signed by the Commissioner of Crown Lands, it's a done deal. Yeah?
Can you talk to me just a little bit about this contractor? Who are these guys? What is their relationship between the agencies you've already? Who are these people?
They're hired. Well, there are three firms. The LINZ, Land Information New Zealand.
Okay.
So there are three firms. Before '98, there was only one firm. Now there's three. At Quotable Value, DTZ, and Opus. And they're sort of land management real estate firms. I think one of them is New Zealand owned. I think the other two are not, but I could be mixing those up. There's about 12 or so individual guys who do the deal.
Okay, so they're
spread across three firms.
They're employed by an administrative agency that declines to have any advocacy role for the Crown to
Correct.
negotiate things they go out and talk to the landholders, the farmers and stuff like that about who's going to be, who's on the other side of the bargain.
The farmers.
The farmers are definitely
Well,
they're on
there's
one
DOC
side.
as well, but that's
Are
a separate story. DOC advocates for conservation and recreation, but DOC, the only people in the room, talking about prices here, and the only people in the room when prices are decided are the farmer,
Yes.
the farmer's lawyer, and the contractor.
Who's on the other side of the transaction then?
Well, see, therein lies the problem, and that was my
It's a
argument.
bilateral bargain for us.
Well, right, so, yeah, that's my thesis of the Fulbright
Okay.
report, that when you assign vested interest and neutral to the same job description, one of those is going to suffer. Either, you can't be neutral when you're sticking up for a vested interest. And if you're neutral, then you're by definition not sticking up for the vested interest, so therefore the public's vested interest in the land will lose. So, yes, that was the thesis of my Fulbright, yeah.
How does a contractor get paid on number of deals closed?
And there are benchmarks. It's not, there's no percentage, like if you get,
Good question, Bob.
yeah,
Good question.
that's, there's no percentage cut. Yes, it's by benchmarks.
Benchmark means what?
Did you get the preliminary proposal advertised? Did you?
Procedural benchmarks.
Yes, procedural.
A checklist.
Okay,
Yeah.
what's the,
So there's
what's
about
the,
33 steps or something.
you mentioned 3 firms. What's the independence of these guys from the eventual developments that occur, don't occur? Do they have their fingers in the pie? I mean, that's what I would guess is the complementarity there.
I don't think there's any corruption going on, but yeah.
These contractors are farm property agents by profession.
Well, perhaps yes, but there's some variation in there.
Or they have serious training in farm valuation.
Yeah, actually, a lot of them are registered valuers.
Yeah, they're up to their they're in this business up to their eyebrows, but typically representing farm interests. They're
Well, I don't know that that's entirely fair. I don't. Again, they weren't allowed to talk to me, so I can't really talk. I can't really tell you. A few of them did talk to me, and so I can tell you about who they were, but it's not going to be a representative sample. They came out of Land and Survey, so they were professional resource managers for the government prior to going into this consulting business. So the ones who did agree to talk to me while I was doing the research before the controversy even erupted, they were Land and Survey people. So that's not entirely fair, no.
But it's really important to understand kind of what's driving the contractors in terms of, do they compete with each other on some dimension?
No, there's no reserve price here.
Well, I mean, does the Crown then say, okay, I've got this block of land, I want these sections for conservation purposes, you guys go out and get it for me? I mean, how does it work? I mean, that's pretty important to know.
Yeah, okay, so there's about 300 leases left to go through. Well, 270 or so. And as a farmer enters the process, it's entirely voluntary. The farmer can back out at any time. The farmer is not compelled to enter. As the farmer enters, they say, okay, closed burn station is going to go through review. They put it out for bids. So there's sort of a request for proposals, and I don't know exactly how they determine which of the 3 firms gets it. I don't know how they determine that, but there are bids involved, and there is some competition involved. After 98, there's competition. Before 98, there was not. Seamus?
Talk a little bit of the process. There's 2 different sides. One with the government's buying on this side.
Yes. Disposition and acquisition. Yep.
On the acquisition, does the eminent domain play a role? You say that the farmer is completely free to walk in or not. He's also free to walk out at any time.
Yes.
So
the farmer has veto power throughout the whole.
So it's only going to be if a mutually agreeable term between the contractor who doesn't give a hoot and the farmer who wants something.
Yes.
Okay, that's
Yeah.
fine.
There's the thesis of my Fulbright report.
For the position, again, it's the same thing. The farmer can choose to walk in, and if the contractor sets the price too high, he says stuff that I don't want to buy, and walks out.
Yes, but it all takes place at. I don't think that there's, in March we're going to decide how much we'll pay for the disposition part, and in April we'll decide how much we're going to pay for the acquisition part. I don't think they're 2 separate deals. But yes, the farmer can walk out at any time. The Crown can also walk out at any time, but the Crown has never walked out. There have been a few, and there's no reserve price set by the Crown, by Lynn. And I asked the contractor again about this because I wanted to confirm that, because it just sort of defies a lot of logic. And he said that there have been cases in which the contractor has set a reserve price. The contractor has said, look, you shouldn't pay more than $400,000. My recommendation is walk away, and the Lynn's has come back in and offered more than the contractor. So again, I can't confirm it. It's based on one report, but I can definitively confirm there's no reserve price, because I asked that of the Lynn's officials as well. So.
And when this process first started, was there any high country land that was freehold?
Yeah.
So there is land out there where there are market prices.
Yep.
So I was wondering how you could tell what the value of the property right to the Crown was. It's easy to tell what the property right of use is because that's freely traded.
Yeah, and I haven't done that. I haven't gotten those transactions data, but there would be some available, especially in Canterbury. Well, there's one. I forget if it's Otago or Canterbury, but one of them has much more freehold land in the high country than the other one. Yeah, Phil?
At the briefing in Bridges Hotel, I asked Kevin Kelly and Warwick Quinn and
Yeah, they don't look at this stuff, though.
They firmly asserted that they never benchmark the outcomes here to private market.
Yeah, so they just asked for they did this valuation report, and the valuation report, I was expecting comparisons, basically all this stuff that I'd love to be able to do, but haven't had time to, haven't had, collected the data. It took me a year and a half to get the data that I'm presenting today, so I was expecting the valuation report to have done, those types of things, but no, they didn't actually look at prices. So, yeah.
I'm going to take a step back to Bob's question about what about managers. I think maybe a relevant piece of institutional detail to sort out is the breakup of Dawsley in the 90s. It had a comprehensive set of activities that it did, and I'm aware that there was a lot of self-selection of managers there to form their own businesses that they don't want to carry out. So there kind of is some institution detail there. I think there's
and the ones who talked to me came out of that government agency.
Yeah,
so they came out of sort of the Forest Service type of institution.
The other one is
or BLM, really.
When Seamus asked the question about the pricing strategy. How does the pricing here, the negotiations here, fit in with 11-year annual price reviews on the lease rates, or do those things just automatically roll over?
Well, that's changing now, but we'll get to rent.
Okay.
Rent has no correlation.
But does Lynn's monitor the 11-year price reviews sort of thing? So does the part of Lynn's that does that talk to the part of Lynn's that does these continuing review price negotiations?
I'm not sure. Lynn's is not big on data gathering. Okay, so we're looking at prices here.
So we get captured.
And no, it's not, and it's a bit more than capture.
Okay.
We went through this before. Capture, to a political scientist, capture has very specific meanings, and there's all sorts of institutional factors that you look for, and some of those are there and some of those aren't. But anyway, so we're looking at prices, and our question is, do the property rights assigned, whether or not they're assigned clearly or not so clearly, do the property rights assigned in the pastoral leases determine the prices paid or drive the prices paid by the Crown and the leaseholders in this exchange? And we did this, but in September, the minister released the individual transactions prices. So when I wrote my Fulbright research, there was only aggregate data because the individual prices paid was classified as commercially sensitive. And then the minister decided that it wasn't commercially sensitive, so he released it. So what we did is we looked at the per hectare price paid by the Crown and looked at the per hectare price paid by the lessee, and then the equalization payment is the net consideration. So far, the net consideration has been in the direction from the Crown to the lessee, in aggregate $15 million. Now, these per hectare prices are a little bit misleading because there's a lot of other variables that go into per hectare prices. It's not just the value of the Crown's interest per hectare and the value of the lessee's interest per hectare. There's also, the Crown is purchasing recreation access across the newly private lands, and purchasing covenants and lots of other things. So this P Crown represents, there's a lot of variables up there on the top, and they're just sort of all smushed in there to P Crown. And we looked at a pricing structure. So a ratio between the price paid by the Crown per hectare divided by the price paid by the lessee per hectare. And this is an expression of the relative interest in the land. Whether it's an expression of, is the Crown's interest 20%? Is it 80%, 90%, 10%, 0, 100? And there's three scenarios that you could envision for this pricing structure. The CL ratio could be 1, which means that the prices are equal. So the value of freehold land, the value of private land, is the same, absolutely the same as the value of leasehold land. There's no difference between leasehold and freehold. And so the Crown's interest, I think that's incorrect. The lessee's interest is basically 100%. So ignore that one. The extensive pastoralism, grazing, is the highest and best use of land. There's no other possible use that would be of more value than extensive pastoralism. Another possibility is that the CL ratio could be less than 1. This seems a bit more likely. In this case, anything you can think of beyond pastoralism will have a greater value than extensive pastoralism. And this is consistent with the empirical economics data, which indicates that extensive pastoralism is, in terms of rural land prices in New Zealand, extensive pastoralism is at the bottom, and then it just goes up from there. So intensive pastoralism is worth about 2 times what extensive pastoralism. And then it goes up to residential subdivision is, in rural New Zealand, is worth 10 times extensive pastoralism. So if the CL ratio is less than 1, then the value of freehold is greater than the value of leasehold. Crown's interest is probably a bit bigger than the lessee's interest, and anything but pastoralism will be worth more than just pastoralism. And then you look at, well, what if the CL ratio is greater than 1? This means that the price paid by the Crown will be less than the price paid by the lessee on a per hectare basis. And that the value of freehold is actually less than the value of leasehold. Yeah?
I must be missing something here. When you've got P Crown, that's when you've got acquisition. So
the price paid by the Crown for each
acquisition of the use rights from the lessee.
Yep.
Right? In which case it has nothing to do with development rights. Right? Because the Crown is only buying the grazing rights. You're buying back the grazing rights, not so that the Crown can develop it, but they can put it into recreation.
Right.
Okay. When you have PVC, you're buying the title. I can see that development rights are important here in terms of willingness to pay, but in terms of willingness to accept, there's a big gap there, which is based on whatever the interest rate of the
Well, yeah. Now there's an argument that we'll be testing, and the difference between willingness to pay and willingness to sell, and value in use versus value in exchange. Yes, that's an argument that we're testing. That the value of the development rights to the present holder, which is the Crown, is might well be very different to the value in use of the development rights to the new owner, which is the lessee. It might be different, might be the same. Those are arguments that we're testing. So our hypothesis is that property rights do drive prices. That the property rights assigned do drive the prices, and that predicts or sort of makes two assumptions. The first is that property rights will be driven by the relative value of these rights, and we also have to know about ownership, so who owns the rights. The relative value is, we can approximate using the empirical data from a paper in 2005 that says that extensive pastoralism is worth, when it gets sold, extensive pastoralism is worth between 2 and 10 times less than anything else. This is an approximation. It's not exact, but the ownership is much more contentious. Who owns the development rights and what value do they have? There's a whole lot of debate about that. Our hypothesis that property rights drive prices predicts that if you run a scatter plot of these ratios, the CL ratio versus percentage privatized, it'll be a pretty flat line. So, because the property rights are assigned by statute and they don't vary much by lease. There will be some variability in the value, so there will be some noise, but the Crown's interest, if the Crown's interest is 10%, the Crown's interest will be 10%, and it'll vary between maybe 0 and 20 or 30. But it'll vary around some value. If the Crown's interest is 95%, it'll vary around 95%. And there will be a noise around a horizontal line at 95%. Yeah?
Yeah, it seems like there's two issues here. I'm confused by why you're modeling it this way. If I were trying to tease out the value of freeholding the land as opposed to working with it as restricted pastoral land, I have a hedonic price model where I go ahead and have the dependent barrel be the tradable price of these leases. Okay.
Right. That's
something else. I know what you're doing, but that's the only way I would know how to, in a sense, attach a dollar value.
I'm not trying to attach a dollar value. All I'm doing is
to even identify. And then the second thing is, it seems like behind this idea, there's both this issue of what's the extra value that, in a sense, pricing out the value of privatizing the land and the extra development benefits. But the other issue that we're assuming to be holding constant is the public, what you call public interest in the land. It could be that the land has some great public goods benefit as a great recreational area. And that can be very different depending upon the plots of land that we're looking at.
Location,
and because it's a public good, that would not be captured in the tradable prices. And so, so that's something that would not be necessarily expected to be the same across these different plots of land.
Right. It would be captured in P Crown, though.
What's that?
It would be captured in P Crown, and that the variable.
P Crown is the price that
the Crown pays to acquire the parcel.
Suppose I have one plot of land over here on this southern slope of the Alps, and some other or eastern slope of the southern Alps, and some other plot of land here, and there's a great public goods value to the land over here.
They really want to establish a park here. Yep.
They're willing to pay a lot over here, but not so much over here.
We tested that.
Unmeasurable.
Yeah. Well,
I believe in contingent value.
But we did actually test that, and we went through.
Because the thing about the key element is an unobservable.
Actually, well, it is observable. If you ask the people who are in charge of advocating for the conservation and recreation interest, or
it has some scale or something, index number.
Well, you can DOC and Forest Bird and, Dawson Forest Bird basically have ideas of what parks should be put where. And there are some pretty high-profile parks that the minister wants to establish. And so you can look at where those parks are, and you can look at the leases that are within the bounds of those proposed high-profile. Chris Carter really wants to, cut the ribbon on this one, and so you can actually approximate it at least, and so you give a 1 to a lease that is going to be a cornerstone of Ahuriri National Park, and a 0 if it is, I'm sure it'll be great conservation land.
Is this what you guys do?
Yeah, I've done that. Yeah.
Okay, so if I shut up, then we'll have a chance to see some of this.
Yes. So the key issue is who owns what rights, and that's what's been going on in the papers for 9 months, and really 15 years, really, because the farmers have been very staunchly advocating that they own the vast majority of the interest in this land. So there are 4 scenarios, and we're testing 4 hypotheses here. The first is that the Crown owns 100% of the value of the development rights. And this is a theory that I sort of put forth. I at least hinted at it in the Fulbright report, and the minister or cabinet hinted at it again in September. And then along with that, you've got Stillman's data that's saying that land with development potential beyond extensive pastoralism is worth between 2 and 10 times more than land that's restricted to extensive pastoralism. Then there's a theory that the value of the development rights is split 50-50 among the leaseholders and the Crown, and that's been put forth by federated farmers. Basically, the argument is that because the Crown can't exercise the development rights and the lessee can't exercise the development rights, they sort of split them. And then there's the argument, it's in the newspapers. I'm taking my arguments from, basically I want to present all the arguments without prejudice and test them against the data and model them and test them. And then there's the argument that the Crown whole owns 0% of the development rights. That the Crown, in 1948, when the Crown established perpetually renewable exclusive occupation rights, the Crown alienated the development rights. The Crown gave the development rights to the farmers. And that's been asserted by the High Country Accord, which is the big farming lobby, and also in the valuation report that the government commissioned and was released in October, but then the government rejected. So the report that the government commissioned said that the lessees own 100% of the development rights. The Crown rejected that, and Cabinet issued a report that hinted that the Crown owns 100% of the development rights. And then there is a argument that the development rights are worth 0. That the Crown's interest is only the net present value of rent. Because the development rights are worth nothing to the Crown because the Crown can't utilize them. That has been put forth about 2 weeks ago by 2 economists at Victoria, hired by the High Country Accord to criticize my report. And so these are the 4 hypotheses, the 4 scenarios that we're testing. Yeah, Seamus?
Yeah, I'm quite okay. Not by anything you said, but based on what you said before about this is all voluntary bilateral bargaining, with no exercise of eminent domain, why has there been a single op-ed in the newspaper? Who cares, right? A farmer comes in, he thinks his right to this, he sits down with an agent of the government, if they don't, they walk out. Their agreement's different from somebody else's. Why does anybody care?
Why does anybody care? Because 20% of the South Island, 10% of the country.
For
the point is the question of
deer snuffers, the trappers, and so on.
The question of who has the rights is going to be irrelevant after the transaction.
It's relevant to the transaction itself, though, and to the prices. Well, that's our hypothesis. Perhaps it is irrelevant.
I mean, I can understand why it's relevant to you, in terms of trying to explain the outcome of prices.
Oh, but why is it argued in the newspaper?
Why were Evans and Quigley hired?
Because my Fulbright report said that the Crown has privatized 60% of the land, taken grazing rights to 40% of the land, and paid $15 million. And it argued that basically what the Crown is getting is worth far less than what the lessees are getting. And so therefore it's surprising that the Crown would have paid $15 million. That I argued that it would be more expected for the balance of payment to go in the other direction. That to acquire freehold title would cost more. To acquire a freehold title to the most developable 60% of the high country would cost more than to acquire grazing rights to the least grazable 40% of the high country. So we're modeling these, and so basically that was my argument. Love it or leave it. And I'm not sure. And as it turns out, the prices aren't assigned the way that I said they were assigned either. And so the High Country Accord got put into high gear, saying, no, she's wrong. Our interest, we own the vast majority of the interest in the land, therefore we deserve all $15 million. We haven't been overpaid at all. In fact, we're getting screwed.
So the answer to Shane's question is it's a political issue because you're basically claiming the Crown has given away a lot of land and the farmers.
Yeah, and the farmers are saying, no, there's no problem at all, we deserve it. So, it's sort of, I sort of started.
Well, now my any taxpayer here, the government's a monopolist, and I'm a shareholder in that monopolist, and the farmer's competitive. Basically, they should be screwing every single cent of service they can if they're acting on my behalf.
But there's a bit of a principalization problem going on.
Exactly.
So we can model these four arguments algebraically.
Farmers are monopolists as well, because the Crown can only negotiate with the actual employer.
And so we've got assumptions of basically we use the High Country Accord economists' assumptions of what grazing and development and things were worth, then we went and modeled using the actual hectares data for who's gotten how much land, what land has gone into covenants, what land has gone into recreation access easements, all those sort of secondary variables that we talked about. We modeled, okay, well, if the Crown owns 100% of the development rights, then the Crown's interest will be greater than the lessee's interest. The CL ratio will be less than 1, and there will be two horizontal lines. One horizontal line for where location is highly desirable, and we observed that by whether it's in view of a lake. So Lake Wanaka, Hawea, Wakatipu, Lake Peko, and then if it's not highly desirable, then the development rights won't be worth as much. The development rights will be worth, we assumed, that all sort of the highest and best use of the land might be intensive pastoralism. Nothing beyond that. It's vastly beyond way out in the wop, no development potential whatsoever. So you've got two horizontal lines, and basically that's the story. That when, no matter who owns the development rights, whether it's the Crown, the lessee, whether they're split 50-50, or whether they're of no value whatsoever, basically you get two horizontal lines with some noise. And the noise is due to covenants and some other recreation access and things like that. So the ownership of the development rights, all it does is change the height of the lines, the y-intercept of the lines. It doesn't change the slope or the shape of them. So while the Crown owns any percentage of the development rights, you've got two lines. A high location value line, in which the Crown, if the Crown owns anything, the Crown will have, the CL ratio will be more in the Crown's favor. So it'll be a less generous price offered to the lessee. And then a not so great location value line, where the Crown's interest will be much lower. And the pricing structure offered to the lessee in this deal will be more generous. When the Crown's interest is lower, then the pricing structure offered to the lessee is more generous. The lessee gets more money per hectare. So that's the story. You've got, and that's our hypothesis. If property rights drive prices, you'll get some variation on a horizontal line, or two horizontal lines, if you include location. That's not the result. Here are the actual results with the CL ratio here. This is a log scale, and the percentage privatized on the bottom. And as you can see, it's not at all a horizontal line. It's a third-degree polynomial sloping upwards. And if you were to do a best fit line, the slope of the line is about 72%, and it's pretty high R squared.
I don't like all those dots above 1 is what I don't like.
Yeah, so we've sort of gone through the logic behind the CL ratio, and when the CL ratio, remember, when it's below 1, then the highest and best use of the land is extensive pastoralism or anything beyond that. Even if it's fertilizer or intensive pastoralism or dairy or viticulture, that anything will have perhaps a higher and better use of the land. This right here is where the highest and best use of the land is extensive pastoralism. This is where the highest and best use of the land is, it's sort of hard to conceive of what the highest and best use of the land is less than extensive pastoralism. It's sort of hard to conceive of an economic rationale for why it would be greater than 1, but go figure they're usually greater than 1, which is why you get an aggregate payment to the lessees of $15 million. So,
doesn't it depend heavily on the level of the rental?
Yeah, you would think. You would think. Yeah, here's the rental.
What I meant was, whether you expect above 1 or less than 1, I have no idea what I would expect until I know something about the rental.
Yeah, well, you would think that the rental might have something to do with prices, but it's quite a weak correlation. So now the government is in the throes of trying to raise the rent by several orders of magnitude in the hopes that it'll get these prices into line. I'm a little skeptical of that because there's very little correlation between.
The trouble with that is that I would expect that the rental would have a heavy impact on the value of giving the freehold to the government, because it's giving up the rental and it puts freehold out to the farmers. When it buys, that is an acquisition rather than disposition. It's also losing the rental because it's taking the land and to do something else with it. So I wouldn't have any idea what the rental rate should do to that ratio at all. It just affects whether or not I expect things to be above or below the line.
Okay, I'm not sure I can really answer that, but we've tested rental against both prices paid, because there's some logic behind what the Crown's interest is the net present value of the rent, capitalization of rent. And so we tested the price paid by the lessee, by the Crown's interest, against net present value of rent. No correlation, or very weak correlation. There's another logic that you could sort of think, well, perhaps the lessee's interest is the net present value of rent, because what the lessee rents is the grazing rights, and so maybe that's some approximation of the value of the grazing rights. So just to make sure, we tested that as well, but no. So there's really very little correlation between rent and any of these prices. Net present value capitalization of rent. That could change. The government is, or the minister is clinging to the idea that raising rents will get these prices into line. And it could. If the rents go way up, then maybe they'll be big enough to drive prices, but that's sort of
kind of... Net present value is less than the TL?
TL. What TL?
So the price paid by the lessee per hectare.
Oh yes, it's far less. The net present value of rent is about $21 per hectare.
Yeah,
and the price paid...
In the scheme of running a pastoral lease, what the heck is the rent?
It's 86 cents per hectare per year. So the average rent per year is about per hectare. Oh no, sorry, not per hectare. The average rent per year is about $6,000. So the average monthly rental is about $500 for these pastoral leases. Of the average size is about 7,000 hectares. So it's very low. If it were to go up, then maybe it would be a more.
The point is that because the price is so much in excess of the rent, and it's all about divvying up the value of the development, the rent is very relevant.
Yeah, right. So maybe if the rent goes up, then maybe it will change.
But High Country Accord argues that only rent is relevant.
Well, and that's what I mean. There's an argument there. We've tested that, and that argument doesn't. That the Crown's interest is the net present value of rent. That may well be true, sort of legally and philosophically, but that doesn't appear to be how the prices are assigned. If that was true, then the prices wouldn't look like this.
What time period do these dots come from?
1992 to 2006.
Okay. Because my guess is that even the variations that occur in those periods, if you're looking at 11-year price reviews from a government department that's been going on for the last 100 years, there wouldn't have been any change. You know, they just roll things over in some mutually acceptable way. It wasn't until the 90s probably people started to think about this.
Well, I don't think they were thinking about it when they. I mean, I think one of the.
Well, the farmers were thinking about it real hard, but the administrators who were doing the things.
Yeah, I mean, one of the big assumptions behind this, when this started in 1992, was that this land wouldn't really be subdivided and it would still keep being farmed, and that hasn't happened. But you make a good point about the change over time. There has been quite a big change over time. If you look at the data before 1998, it's a striking adherence to the dotted line, the best fit line. And the data after 1998 has, it's a significant correlation, or the line seems to explain quite a bit of the variability in the dots. But there's a lot more upward drift. And higher means a more generous price offered to the lessee.
If you threw out the outliers, there wouldn't be any upward drift at all. I mean, just look at the 1.0 to 0, and take those two guys out at the bottom and the two guys at the top, which I tend to ignore, and you've just got a flat line there at about 2, 1.5 to 2, going straight across, so lots of variation. That's the way I'd read it. I'd ignore the extremes.
You'd ignore
those two guys and those two guys there. Just throw those out for a second and say, well, forgetting about those guys, it does look like a horizontal line to me, but that's just my subjective processing of that information.
It's a log scale, though, so this 2 doesn't mean actually 2. 2 means, I think, 10.
Whatever constant it doesn't mean.
I think if it were not on a log scale, if this weren't logged, then yes, it would be a horizontal line. But because it's log, means that
The band is
from
50.
here to there is actually from 0 to 50, or 1 to 50, so that's,
Okay, big band.
yeah.
But you were saying there's an upward slope, that's all, and I just was thinking that you only get that because you're trying to fill in from the right-hand top to the bottom left-hand thing, and I forget those because that's just a heuristic that humans use to fill in dots. Because most of the observations are all in that. Take up 5 of them, and you've got a nice pattern.
R-squared is pretty high, though.
I know, go on, you're doing this.
So, we can safely, I think, reject the hypothesis that a strict interpretation of property rights drives prices. That doesn't seem to be what's going on here. What seems to be going on is that the Crown's interest varies with percentage privatized. So the more the Crown privatizes, the more generous the deal, the more generous the pricing structure that the Crown offers to the lessee. So if the lessee gets to privatize the vast majority of his former leasehold, say 75%, he'll get a more generous pricing structure than if a lessee only gets to privatize 20%. And that's also gone up over time. So before 98, it was much more likely that the lessees had to pay some. After 1998, not very many people had to pay. You can do a histogram and see who has to pay and how much they have to pay. The only time when the average payment goes to the Crown is when more than 90% gets privatized. So between 0 and 89%, the average payment is to the lessee. And so we can safely reject the original hypothesis, which is property rights drive prices. We can also reject the possible idea that the Crown might have a guilty conscience, that the Crown might be trying to create viable farming units, which is a piece of rhetoric that's not in the statute, but it's in a cabinet paper called the High Country Objectives that's been issued twice to no avail, which sort of is a case in point of the principal agent problem. But one of the objectives the cabinet set was we want to establish viable farming units. And so you could sort of think, well, maybe if the Crown takes grazing rights to 80% of Mr. Closeburn's farm, then the Crown will give Mr. Closeburn quite a generous settlement, a more generous settlement than if the Crown will give Mr. Closeburn more money so he can invest in land elsewhere or do other improvements, or just because the Crown feels guilty. And so Mr. Closeburn, who gets to privatize 20%, will get a more generous deal than Mr. Glendine, who privatizes 75%. But that hasn't been what's happened. You can see here's Closeburn down here, and he got one of the worst deals. And then Glendine over here, who's still in the range of normal, but you can see that these guys get much more generous deals than these guys. A guilty conscience would predict the opposite. So if the Crown were to take the vast majority, they'd give a pretty generous price, whereas, if the Crown only takes 2 or 3 hectares, a couple hundred hectares, they won't give a very generous price because they're not really hurting the farmers that much. They're only taking, in these cases, the Crown is taking 2 hectares, 5 hectares. I mean, it's not a lot of land. So we can reject property rights, we can reject guilty conscience. We tested the parks. We tested the desirability for parks. We tested the contractors. Does it vary based on contractors? Does it vary based on length of time to deal, rent, location, stocking units, recreation access? None of those vary with percentage privatized.
How about guilty conscience of farmers?
Yeah, guilty conscience. If farmers have guilty conscience, then yes, that would, but it's hard to imagine.
How about this argument that, I'm the Crown's really high-priced land that I want to get to for conservation purposes, and in a sense, I have two ways of compensating the farmer. I can pay him a high price for the land, or I can give him a lot of land to freehold. In a sense, there's two forms of payment here: high price in nominal terms, and a lot of land that they can go ahead and freehold. And that would be consistent with your upper slope there, your positive slope between the two. When the land's really expensive, okay, and I've got a fixed budget for my limbs or her lunisons, then
there's no fixed budget.
Well, at some level they maybe want to, I'm playing devil's advocate here, but they might want to conserve how much money they're paying out in payments and cash payments to farmers, and thus they pay two ways. They pay high price per acre or per hectare, and they also give they're more generous in how much land they give to the farmer.
The proportion freehold is the.
Sorry, I'm not sure that that's correct though, because they did both.
Well, that's the thing. It's very similar to like hedonic wages in labor markets, where if you have, it turns out that people who are skilled get both high wages and attractive work environments. Okay. Well, it just turns out there's two ways of compensating your people. They compensate them in both ways.
Right, except everything goes up. They all go up together.
Well, that's the same thing. It's the same labor market, the same thing.
Is the proportion freehold the proportion freehold
per lease?
Per lease, when they're negotiating? Because doesn't that just reflect the opportunity cost in? If you've got a highly freehold land and it's got lots of great opportunity costs, so you're going to have to pay a high price.
Well, that you can measure or observe by the stocking unit. And you could sort of think, well, okay, if this is a really highly valuable land, very productive, then it'll have a high stocking unit, allowable stocking unit. And there's also something called the personal stocking rate, which if it's really heavily improved, if there's been a lot of fertilizer put on the land, then the Crown will allow that particular farmer gets a higher stocking rate. So basically, it's a measure of productivity of the land. So you could. One of our hypotheses was that stock unit would be related to percentage privatized, because the higher the commercial productivity potential, the higher the percentage privatized. Because remember, that's what the law says. The law says that if it has commercial potential, it'll be privatized. So a higher stock unit might well be related to percentage privatized. But as it turns out, it's not, and it's not related to the prices either. So it's quite a puzzle. But the question then comes, well, there's still lots of questions left to answer, and I won't be able to answer them all. There's a very strong correlation there. There's not much noise even around that curve. It's not the expected curve. It's not the curve that we hypothesized, but there's not a lot of variability around that. Where does that come from? And what does it mean? And what this indicates is that it's a little bit hard. It's almost a zero-sum line. It's almost the line where no one will pay anyone any money.
On average, zero. It's as if the government were operating on under a zero.
No, it's not on average. It's not on average. It's every single deal. It's every single deal. It's not on average. So it's almost the zero-sum line where in each individual deal, there's some variability, but in each individual deal, if it's on this dotted line, then no one pays anyone any money. The trick is that it's not actually zero. It's 72%. The slope is not zero. So it's not that no one pays anyone any money. It's that the Crown always pays 72% of how much the farmers pay, no matter who gets how much land. And then you figure, well, hang on. You would think that percentage privatized area of who gets how much, that would be a pretty driving factor in the prices. But this line says that the relationship between total cost to the Crown and total cost to the lessee is always 72%. With, not much, and it's not average, and it's not a whole lot of noise around it. So then you think, hang on, could the contractors really have forgotten to put in an area term? Could they have forgotten to put in area Crown? Like percentage to the Crown, percentage to the lessee? It's hard to say. It seems like pretty basic. If they're registered valuers, you'd think that they would put in the number of hectares. And also, what's the 72% about? Well, it turns out, this is just a hypothesis, it's a coincidence in that who knows if it's causal or not, but Treasury, back in the 90s when the whole thing was starting, Treasury, all the government agencies, sort of DOC put in some predictions and sort of recommendations, and Lynn made some recommendations, and Treasury made some recommendations. Treasury said we should be making money on this deal. What the Crown is going to be giving away is worth more than what the Crown is going to be getting. And the Crown's interest in this land, in this 2.4 million acres, the Crown's interest in this land is about $50 million. That's what Treasury said. And they said the lessee's interest in this land is about $36 million. And I read that. I read that, a year ago, and I read it again just a few weeks ago after we did all this. And I thought, I'm just going to buy those. What do you got? Whoa, 72%. And who knows if it's causal, but it's the same number. Yeah.
So the dotted line that you put through is nothing to do with the data constructed from 72%. Is that right?
Well, it's the best fit line and it's the 72%. Well, the first thing we tried, the first dotted line we put in is the zero sum.
Right.
What happens if no one pays anyone any money, and it's a little bit too high?
Then you've got a millimeter higher.
Yeah. So then we did the best fit, which turns out to be 72%. So this is the best fit line, and it's the 72%. The zero is a little higher. And so there are a couple of possible explanations, and this is sort of where we're going next. First of all, you have to ask mathematically, how do you get from a flat line, the predicted flat line, to an upwardly sloping line? Mathematically, the only way to do that is to assign some form of a negative value to the Crown's interest. No matter how you configure Crown's interest, lessee's interest, or development rights, grazing rights, no matter how you choose to express the algebra that's going on here, the only way that you can get from a flat line to an upwardly sloping line is if the Crown pays a per hectare sort of liability factor for every hectare that it privatizes. So the more the Crown privatizes, the more it pays. And there are a couple possible explanations for that. The first is just the principal agent's desirability of closing the deal. The contractors and LINs measure their success by the number of deals they strike. What better way to strike a deal than to offer a very generous one? The more they privatize, the more generous the deal is. And that's consistent, or probably even stronger than the politics administration dichotomy. In the Fulbright report, I argued that the Crown wasn't sticking up for itself. That the politics administration dichotomy sort of caused the Crown to be neutral, and so rather than stick up for the Crown's vested interests, the Crown just sort of said nothing. I think that, or the Crown was neutral, and that caused the Crown's interest, or the Crown to underestimate its interest. But the Crown isn't actually underestimating its interest. The Crown is allowing its interest to vary with percentage privatized. The more the Crown privatizes, the more it's willing to fudge its interest to make it lower. So in the top corner, even if you take out the outliers, when the Crown privatizes 95%, its interest is about about 2%. But when the Crown only privatizes 20%, the Crown's interest is somewhere in the 90s. So the Crown isn't underestimating its interest; it's just willing to fudge it. So,
would that be consistent with the idea that if the incentives for the agents to close deals, then what they're actually dealing with is not a price per hectare, but essentially a lump sum payment to close the deal, which bumps up your price per hectare, so you do get that upward slope line. So the payment is not really actually per hectare; it's essentially we're dealing now with lump sum payments to close deals. The percentage of land that's privatised is therefore irrelevant.
Yep. So therefore, the 72% it could actually be, and 72% is as good a number as any that came from Treasury. And so those arguments are sort of consistent. That rather than sticking up for itself, the Crown actually bends over backwards to fudge its interest in order to close the deal. That you can sort of stick up for because it came from Treasury, and Treasury always sticks up for the Crown's financial interests. But then you can consider this idea of the liability factor. That mathematically, to get from a straight line to an upwardly sloping line, the Crown's interest has to have some negative. There has to be some per hectare payment that the Crown is making. Every time it privatizes a hectare, it pays a little bit more. So there has to be some positive value assigned with privatizing land. And so it's so much in the Crown's interest to get rid of this land that there's a liability assigned. And there are, if you read the history of this policy way back into the 80s, there are some ideas consistent with that. First is it costs the Crown a lot of money to administer this land. The rent they get is bugger all, and they pay more in administrative costs to administer the leases than they get in rent. So there's an administrative liability. There's also the sort of trickle-down economics theory that the development rights are being held hostage by these leases. And it's so much in the Crown's interest to release the development rights from their prison of pastoral leases. It's so much in the interest of the country that the Crown is willing to subsidize the release of these development rights. And the Crown is willing to subsidize the diversification of land use in the high country. So there's the trickle-down economics theory. And then my favorite is the radioactive rabbit. That when you start thinking of liability factors in land, if you're American, the first thing you think of is the Superfund, where the U.S. government owns a lot of radioactive land from atomic bomb testing in Hanford. So they own land that is so contaminated that it's a liability. And so it pays, rather than selling land at a positive price, it sells the land with a negative value in order to subsidize the new owner to to do environmental remediation. So it pays the new owner to take the land with the understanding that he or she will get rid of the radiation. So when this policy started, it started under the auspices of the Rabbit and Land Management Program in the late 80s. And the goal of the Rabbit and Land Management Program was to get rid of rabbits, because they were such a problem that the land really was a liability. And it was one of the reasons, one of sort of the goals for diversifying land use was to get rid of rabbits. Rabbits don't like vineyards. Rabbits don't like condominiums. Rabbits don't like subdivisions. Rabbits do like sheep farming though. So diversifying land use was a tool to get rid of rabbits.
That's scary.
You know,
it's a great story, but we live in a country like this.
It's consistent.
I think
correlation does not indicate causation, but it's consistent. And I don't mean to sort of say any of these are. They're just possibilities, and we're thinking of new variables to test and see if we can test any of these hypotheses more closely. But these are the hypotheses we've got, and I'd love to hear any others. That's all I've got.
I propose, because the college has a non-trivial function beginning at 4 p.m., that we close now. In any event, you got ample feedback in the form of aggressive questions during the talk, so there's no point in creating a lot of time for it now. Okay?
Thanks.
You're finished, Dan, I presume.
Yeah, that's it.
After all, I know that's your last slide. Okay? Let us thank Anne in our usual way.